Imagine you're charged with a crime. You take time off work, you hire a lawyer, you spend weeks worrying about what's going to happen. And finally, your first court date arrives. The hearing lasts maybe 3 minutes. The judge asks a couple of questions, sets another hearing about a month away, and that's it. You walk out thinking, wait, that's all? I took time off work for this? Then you come back a month later, another short hearing, another court date, then another. Before you know it, 6 months have gone by and it feels like your case still hasn't gone to trial. One of the questions I hear most often is, why does it take so long? What is everybody doing between court dates? That's a fair question. From the outside, it can look like nothing is happening, like everyone is just kicking the can down the road while your life is on hold. But here's what most people don't realize. The courtroom is only the tip of the iceberg. Most of the important work in a criminal case doesn't happen in front of the judge. It happens between court dates. Today, I'm going to pull back the curtain and show you what is actually happening during that time, because once you understand what's going on behind the scenes, those weeks between hearings and the months it takes to resolve many cases start to make a lot more sense. Before we jump in, I do need to mention that this video is for educational purposes only. It's not legal advice, and watching it does not create an attorney-client relationship between us. So let's start with one of the biggest misconceptions people have about criminal court. One of the biggest misconceptions people have is that the courtroom is where criminal cases get worked on. It isn't. Think of it this way. Imagine you're building a house. The workers don't stop construction every single day so they can give the building inspector an update. They spend weeks doing the actual work. Then at certain points along the way, the inspector comes out to check the progress and make sure that everything is moving in the right direction. Criminal cases work a lot like that. The courtroom isn't where most of the work gets done. It's where everyone checks in on the work that is happening and has been happening since the last court date. The judge wants to know things like, has the prosecutor turned over all of the evidence yet? Has the defense had enough time to review it? Are there any legal issues that need to be decided? Is the case moving toward a resolution, or are we heading to trial? Those questions usually don't take very long to answer. That's why many hearings only last a few minutes. The hearing isn't short because nothing is happening. The hearing is short because the work was happening before everyone walked into the courtroom. And after that hearing ends, everyone goes right back to work. So if the courtroom isn't where the work happens, where does all the work actually happen? Well, let's start with the prosecutor. So if the courtroom is just a checkpoint, what is everyone actually doing between court dates? Let's start with the prosecutor, like I mentioned. A prosecutor's job isn't just to walk into court and argue. Before they can make decisions about your case, they have to understand it. That means reviewing police reports, watching body camera footage, looking at photographs, reading witness statements, waiting for laboratory testing, reviewing forensic reports. Sometimes they're waiting for fingerprint analysis. Sometimes they're waiting for DNA results. Sometimes they're waiting for medical records or surveillance video. And remember, prosecutors aren't handling just one case. Many prosecutors have well over 100 active cases at any given time. That doesn't mean that every delay is justified. There are certainly times where cases move more slowly than they should. But in many cases, the prosecution is still gathering information that they need before they can make informed decisions about what should happen next. Once they've reviewed that evidence, they have another very important obligation. They have to turn that evidence over to the defense. Lawyers call that disclosure or discovery. And that's where the next phase of the process begins. Once the defense receives that evidence, our work is really just beginning. A lot of people imagine that a defense lawyer gets the police report, reads it once, and is ready for court. I wish it were that simple. Depending on the case, we might receive hundreds of pages of reports, sometimes thousands, hours of body camera footage, surveillance video from multiple locations, 911 calls, crime scene photographs, laboratory reports, phone records, medical records. And our job isn't just to read it, our job is to analyze it. Does one witness contradict another? Does the body camera match what the police report says happened? Did the officers follow the law during the investigation? Is there evidence that the prosecutor doesn't recognize as being important? Are there witnesses we should interview? Should we visit the scene ourselves? Do we need to consult with an expert? Sometimes, after reviewing all of that, we identify legal issues that need to be brought to the judge's attention through motions. Other times, reviewing the evidence changes how we advise our client about the risks of trial or the strengths and weaknesses of a plea offer. In other words, receiving the evidence isn't the end of the process, it's the beginning of ours. And while both sides are reviewing evidence and preparing their cases, they're also talking to each other, because not every criminal case goes to trial. While both sides are reviewing the evidence, they're also talking to each other. Contrary to what you might see on television, criminal cases aren't usually negotiated in one dramatic conversation in a courthouse hallway. Negotiations often happen over weeks or even months. Why is that? Well, because the information keeps changing. A prosecutor might review additional evidence. The defense might identify problems with the state's case. A witness might become unavailable. A laboratory report might finally come back. A legal issue might come to light that neither side recognized at the beginning of the case. And as both sides learn more, their assessment of the case can and tends to change. At the same time, the attorneys may also be researching legal issues and filing motions asking the judge to decide important questions before trial. Maybe the defense believes that certain evidence was obtained unlawfully. Maybe there's this dispute about whether a witness should be allowed to testify. Maybe one side wants to limit what the jury will hear. Those issues often require written briefs, responses from the other side, and sometimes separate hearings before the judge can make a decision. All of that takes time. And while it's happening, the next court date may simply be an opportunity for everyone to update the judge on where those issues stand. Of course, even if both lawyers are completely ready, there's one more factor that affects how quickly a case can move: the court's own calendar. Even if the prosecutor's ready, even if the defense is ready, the case still has to fit on the court's calendar. Judges don't hear just one case at a time. They're managing dozens and often hundreds of active cases. There are only so many judges, only so many courtrooms, only so many prosecutors, and only so many defense attorneys. And some cases require enormous amounts of court time. A homicide trial, for example, might occupy a courtroom for 4, 5, or even 6 weeks. During that time, the judge can't be conducting another jury trial in that courtroom. So the court has to balance the needs of every case on its calendar. Sometimes another trial runs longer than expected. Sometimes an attorney has another trial that's already underway. Sometimes a key witness isn't available. Sometimes the judge has hearings in other cases that simply have to happen first. That's one of the reasons criminal cases often move in stages rather than all at once. The court brings everyone together periodically to make sure that the case is still moving forward, to resolve issues as they arise, and to schedule the next step in the process. From the outside, those hearings can seem repetitive, but each one is another checkpoint, making sure that the case continues moving toward a resolution. So why are criminal court dates vary weeks apart, and why do so many criminal cases take months to resolve? Because the hearings themselves are only a small part of the process. Between every court date, prosecutors are reviewing evidence, defense attorneys are analyzing that evidence, meeting with clients, conducting investigations, researching legal issues, filing motions, and negotiating with the prosecution. The court is managing hundreds of other cases while making sure that each one continues moving forward. In other words, the real work usually isn't happening while everyone is sitting in the courtroom. It's happening in the days and weeks between those hearings. Now, does that mean every delay is necessary? No. Like any large institution, courts can experience scheduling problems, staffing shortages, and unnecessary delays. But many of the weeks between hearings aren't empty time. They're the time that allows both sides to prepare thoroughly so that important decisions are made based on as much information as possible. So if you ever leave court after a hearing that lasted only a few minutes, don't assume that nothing happened. That hearing may have been brief, but the work that made it possible probably wasn't. If you found this video helpful, consider subscribing for more videos that explain how the criminal system actually works, what your constitutional rights are, and how to better understand the process if you or someone you care about is facing criminal charges. I'm Chorny. Your rights matter. Protect them. Stay safe, and I'll see you in the next video.